Dear webinar participants, it is great pleasure to present you Module 6, Intellectual Property and its Importance. We will talk about the importance of IP for knowledge-based entrepreneurs. I'm Professor Ivan Stefanic, and I'm your host today. It is about intellectual property protection and management, but even more, it is about making money on intellectual property. So our webinar is organized in 9 chapters. We will cover today IP and your business, understanding the bigger picture, copyrights in your business, industrial property in your business, other forms of IP in your business, IP strategy in your business, commercialization of IP, do's and don'ts, resources and help, and at the end we will have small IP quiz. Don't you worry, we will have the answers on all the questions, so you can check your progress during the webinar. But before getting deep into IP and commercialization, let's define our basic terms. Every company has business assets, and those assets are tangible, like built-in machinery, and intangible. And when we talk about intangible assets, we are considering intellectual property. And intellectual property is all what belongs to creation of the mind, from very technical to very artistic. But they have one thing in common. They are used in business context. So let me take you to the journey and explore options available for commercializing intellectual property. Chapter 1 is about intellectual property and your business. The purpose is to give you a better overview of the whole playground, understanding of the bigger picture with help of IP tree story, which is gamified learning experience that integrates entrepreneurial teaching and IP teaching together. We will pay attention to 3 different topics: what options are available, what are possible benefits, and who are the most important actors. So let's see the IP tree story. When entrepreneurs have novel product, process, or application of existing product or process, they know they could file a patent. But they also know patents are complicated. Patents are expensive, and it takes long to get one. So for that reason, they do not file as many patents as they could. All those entrepreneurs who pay attention more to appearance of their product and less about functionality, they know they are just fine with protection defined by industrial design. It's cheaper, it's faster, but they still don't file as many industrial design as they could. But they do file a lot of trademarks, and they utilize them properly. Aware, well-educated entrepreneurs know if they combine those 3 instruments, they get better protection. But if they think that's all what they could do, well, they are really far, far away from the truth, because the whole playground is a little bit different. It looks like this. And for all those who thought those 3 instruments are the only available instruments, that could be a bit overwhelming. And then there is another layer of complication. It's like this. Different roads lead to same places. And then when you plug in different languages, currencies, specificity of national or regional systems, it gets even worse, and we get less instruments, patents, design, and trademarks filed. So how to help? Let's go back to 3 analog. Let's do some classification. It's not as bad as it looks. First of all, this branch, those are copyrights. They are fairly technical or fairly artistic, depending on the leaf or sub-branch. And they are in certain cases very well connected with related rights. For example, you have a music. Yeah, very few people could understand music just from reading notes. They have to listen performers. So it makes sense. Be aware, copyrights are frequently associated with a lot of related rights. And then branch, most important for technology-based, knowledge-based entrepreneurs, industrial property. Our famous patents, industrial design and trademarks, but also topography of semiconductors, new plant varieties, geographical indication, and protection of origin. And then whatever is not classified in those three groups, that goes to other IP, soft IP. And we will handle each and every of those groups separately in the later. So that's intellectual property. It is creation of people. Could be stroke of genius, but could be also result of hard working for years or even decades of interdisciplinary teams. A lot of institutions involved. And let's talk about fruits that this tree could bring. If you expected income, that's fine. But first of all, that's freedom to operate. And we will explain that later. And then this could be collateral, entry barriers for your competitors, improved image, but of course, source of income. And then increased market value. And a lot of entrepreneurs are using it, particularly with that benefit. And then you might influence the industry. You get peace of mind in the end. And then you might even have some unprotected IP. You could be aware of it or even not aware. But pay attention to that, because this unprotected IP is easier to infringe. Okay, let's talk about researches produced by other people. Those are open innovation results. And if you are ready to accept that concept, that could significantly improve your financial performance. Let's talk about agents. There is a lot of reliable, hardworking aid that will help you to get what you want. They are patent and trademark attorneys. There are a lot of paralegals, about clerks in national, regional institutions in charge of handling your proceedings. A lot of them. But there are also some bad guys. Those bad guys can harm you. If you do wrong things or omit important steps, or even if you don't, be aware of the bad guys. And then there is one specific moment. Good guys could work against you as well, because they could be hired by your opponent, your competitors. So be aware of that fact. And then there are a lot of institutions. I just put one, EU IP Help Desk, and we will discuss that in Resources and Help chapter. So, when is the most appropriate time to start your IP protection? Okay, but let's say when entrepreneurs usually do that. A lot of my clients start doing that once when they receive a fancy envelope with killer letter telling what's wrong. Yeah, I would say if we go to tree analog, it is like that. Thinking about to start your IP protection once when your apples are half eaten seems to me a little bit too late. Not even now, because a lot of flowers could already be infected with bug tags, and it's already too late and you don't know that. So the most appropriate time is at the very beginning, while all these IP things are still buds. But be aware of one important thing. That's your IP. That's your IP tree. But there is a lot of IP trees owned by other guys outside. And if you don't pay attention to that, you can easily infringe their IP and get yourself into trouble. Or if you don't pay attention to your own IP, they might infringe your IP. Because there is a lot of agents of different kinds and a lot of institutions, different interests. But let's pay attention to your interest. You have IP goals, you have business goals. Your IP goal, primary IP goal, very elementary, is to secure freedom to operate. And then, in business sense, okay, it is to earn the money, but it's also to remove the risk. So pay attention to that. Then, when bad guys can hurt you the most, well, there are critical moments, and when you don't know what are you doing. So be aware, you will receive a lot of tempting offers, which are actually useless and in most cases harmful. So pay attention to hustlers. And for that reason, get yourself a decent, highly trained professional aid. Why? Because innovations and protected IP might be the most valuable asset you will ever own. And this is the way to achieve success by playing smart, not working long hours. And this is even more important if you are operating off capital. You simply have to do even more and play smart. Chapter 2 is about copyrights in your business. We will discuss following topics. First, especially designed for those who are artists or active in creative industry. Second, for those who are engineers. Third is about author's rights and related rights. Fourth, about scope of protection. And the last, about NFTs, non-fungible tokens, combination of art and blockchain technologies. So let's see chapter 2, copyrights in your business. Let's talk about IP. Copyright and related rights were branches of the IP tree to the right. And it is important to mention them together because most beautiful music without performers will not make sense. So we need them to get the artwork to the customers. Then industrial property and soft IP. And 3, analog. This is copyright, fairly technical or artistic, depending on what leaf or what branch you are looking for. It is famous letter C in a circle, depicts, label every copyright if it's in a graphical form. So picture and poster labeled with C will indicate that this particular artwork is copyright. And let's talk about copyrights labeling. If we have graphic artwork, it is labeled with C in a circle, immediately followed by the year of first publication, and then copyrights owner. Copyrights owner could be physical person or company. But what if we have sound recording, phonograph? Like we could have a sound recording on this webinar. And this copyright is labeled with the letter P in the circle, and that comes from photograph. So that's how we label, and we have to label our copyrights properly. Again, immediately followed by year of first appearance and copyright owner. Let's talk about copyrights. We said protection arises automatically on creation, and there is no necessity to make any filing. But you should be aware, if copycats appears, it would be very beneficial to be able to prove that your date of publication was earlier compared to that. And for that case, it is possible to register your copyrights in a very particular way. And then let's talk about how the protection lasts, how long. It's usually 70 years after the death of creator, but there are exclusions of that, especially if the work was not published or creator was an anonymous or used a pseudonym, and this protection could go up to 120 years. And it is obvious that copyrights could be serious business, and you actually might continue earning money even when you're dead. And there are some top dead earners in 22, and you probably figure out they are earning much more while dead compared to early beginning of their career. It is powerful concept and sound business. But let's reveal more possibilities, for example, of a visual art. It is a lot, from bumper stickers to marble sculptures, fresco paintings. Just imagine. A lot could be artwork, and these artworks could be deployed in various business models. More about business models we will find out in chapter IP commercialization. And let's talk about new stuff. Let's talk about NFTs. NFT stands for non-fungible tokens. It is crossbreed between artwork and blockchain technology. And since every artwork in this way is unique, you can secure exclusive ownership, and for that, that could become an asset, like a video game or tweet or poster. Here is an example. Bored Ape NFTs valued about 300,000 US dollars, sold by only 3,000 because owner misplaced the decimal point and transaction was agreed in cryptocurrencies. So wrong decimal points and a lot less money. But be aware, your artwork combined with block technology is a way to opening totally new business models you possibly did not see before. Chapter 3 is about industrial property and your business. This is the key chapter for knowledge and technology-based entrepreneurs. We will discuss patents, designs, topography of semiconductors, trademarks, protected plant varieties, and protected geographical indication and protected designation of origin. So let's see industrial property and your business. Patent is a very powerful instrument for protecting your IP. You can patent product, process, and application, as long as you have novelty of invention, inventive step, and industrial applicability. But let's say, what's a patent? Patent is technical solution for a technical problem. It is invention. And definitely it is also exclusive right given to the inventor or owner of the patent for commercial exploitation of the invention. It's always territorial, pay attention to that. And then there are prerequisites already mentioned, but let's move on. Let's see how it actually looks. This is patent for a folding bike. It is 20 years of protection without renewal, starting with the date of filing. And let's see where this patent comes into strategic goals and business goals of your company. It could provide freedom to operate, but not automatically. Let's dive deeper into this. We already said 20 years of protection for folding bike. And then suddenly a new guy in the block with revolutionary rotatory folding mechanism, no hinge mechanism. So does he have freedom to operate? Yeah, that would depend on the quality of previous application. If folding bike included other possibilities than hinges, then it could be a trouble. But there is a way around. You can swap licenses and continue doing your business. If you are not so much about functionality, but about the appearance of your product, industrial design might be just the right way to protect your IP. Industrial design are focused, as we said, on appearance. Protection is given up to 25 years without renewals and could have interesting effects on your business results. Here is a plain funnel. It costs €1.29. Here is a very special Pinot, the sweet nosy funnel. It costs 17 euros. But I just wonder, is that really legal? Because Pinot, that reminds me of Pinocchio and Carlo Collodi novel. So let's see. Carlo Collodi died more than 70 years ago, so there are no copyrights associated with Pinot. Let's see, how about Enrico Mazzanti, first graphic designer, passed away a long time ago, no copyrights. Next step would be to check design view, existing design, and it's obvious. There are only 5 designs and none of them not even close to our Pinot, the funnel. And then the last step, we should check trademarks, and if that's okay, we are good to go. And yes, let's talk about trademarks. Trademarks are different. Verbal, figurative, combined, 3D, color, sound, even smell. So trademark is sign or a combination of signs intended to identify and distinguish the goods of different enterprises. So, and it's important to say those goods and services are divided in 35 classes of goods and 10 classes of services. So it's not that you are getting protection granted for all services and all goods automatically. And then what can be protected? We already said various combinations of figurative and verbal expressions, even olfactory signs. Let's see the value of trademarks. Those are top 10 trademarks, and you see its value is considerable. But entrepreneurs went far away from verbal and combined trademarks, now or more in colors, and T-Mobile went even further. Aside of filing magenta for their color, they designed a special T-Mobile sound, and it works well. Let's see what are requirements. Trademark should be distinctive, not deceptive, not descriptive. Of course, in line with law, public order, and morality. And duration of protection is 10 years, but it's renewable indefinitely. So this is the only instruments that could run forever, assuming you're going to keep protection valid. And they have important role in your brand. And let's see what could happen when you combine patent, design, and trademark in your business. Okay, if you go too far in the wrong direction, most likely nothing would happen. But if you pay attention to details, develop your brand, and a lot of could happen. And in certain cases, spectacular things could happen. So the theories was sold for more than $4.5 million US. So pay attention to your IP because it could be the most valuable asset you ever own. We did not talk about topography of semiconductors and protection of new plant varieties. They are for very specific market niches. We could only say topography protection is given for 10 years and plant protection for 20 or 25 years, depending on the kind of tree. But let's talk about a very special group of signs, marks of geographic origin and designation of origin. Those marks are really different compared to ordinary trademarks. Ordinary trademarks are here to help us distinguish one entrepreneur from other. They are, in a way, signposts for first or consecutive purchase. Or if you are not happy, they are signed not to repeat the purchase. Marks of geographic origin are really here to point out very special quality, which is really sourced from this particular geographical location. So pay attention to those signs that are very different and could help you to make a better decision regarding your purchases. And definitely, you can better set up your future business. Chapter 4 is about other forms of intellectual property in your business, so-called soft IP. We will discuss following: internet domains, brands, profiles on social networks, databases, internet search engines algorithms, company names, email addresses, tweets, and trade secrets. Let's explore other forms of IP in your business. Other forms of IP or soft IP is a really heterogeneous group of IP. So let's find out more about that, starting with internet domains. Here is a list of 25 most expensive domain names publicly reported. And as you see, they go as high as 50 million US. And looking closely, you see they are mostly very generic. Fund, insure, private jets, business, diamond, beer. So whoever owns it could do a serious business with it. So domain names registered on time are really very valuable asset. Let's talk about personal name and business names, and I will use a famous case. I hope you watched the video. It is possibly a romantic version of the real events, but frankly, this is it. Glorious name, McDonald's, and I have to have it. You don't have it. Are you sure about that? And it was like that. Ray Kroc, after all, ended up owning McDonald's, and that became a serious business, even though that was a personal name from other person. Let's talk about business secrets. Business secrets are very powerful instrument to protect your confidentiality when it comes to IP, assuming you are paying attention to security. Otherwise, makes no sense. So some powerful businesses are using business secrets because there is no limit on that protection. Patent is fine. It's even great in some cases, but it would expire after 20 years. Having that kept as a business secret, you could hold your competitive advantage as long as you keep confidentiality of your business secret. So be aware what is your IP, keep it confidential, and pay attention to keep it not only against your competitor, Some people within your system could be future infringer as well. So sort out properly your employment contracts, your subcontracting contracts. Pay attention to those guys who are now your friends and associates, and in the near future might be your competitors. Let's do the test. Let's see what could be IP in your product if this product is suitable for IP protection layers. And let's take a famous example, Coca-Cola bottle. So let's see what is IP and how we could protect it. Okay, we know formulation of the beverage is trade secret, well kept for a pretty long time. Then we have soft IP, company name registered at the trade court, registered domain, Coca-Cola company. Then we could have copyright protection for text on the label. We could have patented cap on the bottle. We also have registered trademark, well, we know that. But we also have registered 3D trademark, a shape of bottle, with changes over time. So one little product and at least 6 instruments to protect IP. So be aware, learn from masters, and protect your IP properly. Chapter 5 is about IP strategy in your business. We will discuss IP creation, IP protection, with special attention to filing and managing IP, prosecution, and defensive patent filing. We will also discuss IP commercialization with 2 cases. First one, when we rely exclusively on our own IP, and second, when we accept open innovation concept. So let's see IP strategies. So far, we learned the basics, the main instruments to protect our IP. It's right time to define your IP strategy. And as you see, it starts with IP creation. That could be, as we previously said, stroke of genius, but could be also a result of a long-term and comprehensive research and development process, which takes years, maybe decades, and involves partners from many countries. It is absolutely important to regulate your mutual relationships on the contractual base, especially when it comes to existing and future IP. So pay attention on IP protection and ownership, even at the moment of creation. And then, assuming you've done all right, it is time to protect your IP. So first thing is filing and managing your applications. But be aware, create the scope of protection you are ready to enforce. Do not start that many applications with no idea how you will enforce them. And then consistency is a big word here. You might even conclude that it's not worth filing a patent, but consider defensive patent filing just in case. If this goes right and some other guys file patent, and think about getting you out of game. Defensive patenting could prevent that scenario. And then if creation and IP protections are done, you are ready to commercialize your results. Many corporations previously really insisted on relying exclusively on their own IP. But recently, there are more supporters of open innovation. That's a concept in which you are ready to commercialize other guys' IP, and eventually you are ready to give your IP to be commercialized by other guys. But be aware, open innovations is not equal to free innovations. There are still fees and compensations and royalties, but it is just about attitude. You are ready to use and let your IP be used by other guys. But let's go further. Well, yeah, you notice you are not alone in that. There are possibly additional research partners. There are investors. There are even license recipients who have very specific requests. So pay attention to interest of relevant stakeholders. Okay, step number 1, creation. So what do? You are a researcher, you generate and increase your innovation potential. Then step 2, protection. It is prerequisite for successful IP commercialization. You are becoming visible, enforceable, and competitive. I would say one thing more. You are even becoming a desirable business partner. And then you are ready to exploit your IP and add value by commercializing it in a different ways. And we will find out how in the next chapter. But as we said, different stakeholders, different interests. Researchers, well, they would like to have a newest equipment, keep high innovation capacity, publish a lot of papers, and secure contracts for future research. Businesses, on the other hand, oh, they would like to acquire IP to secure competitive position, and they would definitely like to exclude competitors. So be aware, interests are not the same, but you still might be alliance. Chapter 6 is about commercialization of IP. And in this chapter, we will talk about innovative entrepreneurship. Innovative entrepreneurship is something related to knowledge-based, technology-based entrepreneurs. They have to create, or someone else supposed to create IP, then this IP have to be protected and then eventually commercialized. It is a lot about innovative entrepreneurship specifics. And then you would need a business model. There are different business models suitable for commercialization of IP. Next topic is strategic interest of different stakeholders and how to resolve that situation. Then several cases of different type of commercialization. One, in your own or shared company, selling IP, licensing out, and we would also tackle the case when you are taking someone else's license, licensing in. So let's see details about commercialization of IP. So here we are in the chapter of commercialization. I could say that's my favorite chapter because so far we created our IP, we protected properly, and now we would like to capitalize on the market. So let's see what is needed. Yeah, we definitely need innovative product or and service. But how to make the money? The answer is innovative business model. And then there is a lot of guys with innovative products and innovative business models. What they miss, it's innovative implementation. And then if you pay attention to those three components, you might expect success. And then in certain cases, even that is not enough. You need, in some cases, for novel products and services, culture and paradigm shift. You have to affect your customers, to educate them, help them to adopt new technology, new products. So let's talk about innovative products. They are produced in research institutions or departments run by universities or companies. It's interesting, all those grants, university researchers treat as an income, but not the businesses. They said that's investment, and they keeping that in their business books in red. It's investment, it's minus. And the bigger research, the further from the market. The valley of that is bigger and deeper. And they know they don't have all the money necessary at the beginning, but they're going to get it in several stages. It's a long and painful and uncertain process. And for all those reasons, not many would succeed. But knowing the specifics, the details, could set you for success. Let's talk about business models. Well, that's a very powerful table, very concentrated. You technically have only 4 archetypes: creator, distributor, owner, or intermediate. And you have 4 types of assets: financial, tangible, non-tangible, and human resources. So pick your model. It is not necessarily that you are everything, meaning inventor, chief technical officer, business person, entrepreneur, chief executive officer, chief financial officer. It's difficult to be excellent in everything. So nowadays, for high-tech and global businesses, that's a teamwork. So pick your position wisely and pick your business model correctly. And if I have to summarize this webinar into just one graphic, that would be it. It's a lot of moving parts. A lot of things could go wrong. And at the first sight, you could say it's complex. It's too complicated, actually. It's overwhelming. What's the purpose? But then help yourself. Divide that into subsystems. And then when you see the moving of blue balls, it's actually fairly simple, and it's logical and supports effectiveness of other parts. It's not that dumb, and it works. So let me tell you what those blue balls are. Those are everyday assignments that every entrepreneur is supposed to do on a regular or occasional basis. And yeah, the cruel fact of life, we don't know all of that. We are not good at, not good enough. We hate or don't have time. But don't you worry about that. There is a solution for every single case. And that's why we have effective management. So pay attention to those blue balls. And then there is a lot of IP in various components. So without taking care about your IP properly, could you actually expect the success? I'm not so sure. So pay attention to your IP, but do not neglect entrepreneurial side. Entrepreneurs are not that good at research and development, but they are quite good at making money. So create a team that have a hacker and a hustler, which are effective in technological part and business part. And then now we are coming to example, food and drinks, labeling. It's confusing to operate in hypermarket open 24/7, all year around. It's difficult to be supplier, but it's also difficult to be a customer because a lot of informations are mandatory. And then in addition to that, a lot of things are optional. They are in many cases useful, but in many cases they are actually useless, overwhelming and confusing. So pay attention to that as well. It is not only about IP and business, it is about effective marketing communication. So let's talk about brand development, differentiation, and development of customer loyalty. Branding could be an important component of business for several reasons. It's a signpost to repeat a purchase or make a first purchase in the first place. Could be entry barrier into sector and could be source of additional revenues. And then we did not mention earlier, but trademarks work as an unregistered one signed by TM or registered one signed by C in a circle. So good brand or trademark should be easy to read, spell, pronounce, and remember in all relevant languages, and without adverse meaning in slang or undesirable connotations in original and relevant languages, and adaptable to all advertising media. And I know it's difficult to have one trademark suitable to be used on the post stamp and billboard. It's difficult, but there are certain varieties and you can adopt it. And then if you use proof of environmental consciousness, social responsibility, fulfillment of religious standards, nutritional requirements, or simply add something that would make my purchase easier and faster, you are really in better position. But please do not use redundant or confusing signs, including medicinal claims. Do not promise where you cannot fulfill. And let's take another example. Wine producers. They are using a lot of labels, which are technically medals won at various exhibitions. They are using copyrights on their labels. They are certified as organic in many cases. They're creating our own blends, and they use geographic indication and proof of origin a lot. And then let's have a real life example how it's done from the very beginning. Assume you want to protect a trademark for product of superb quality. And let's say it's dynamite liquor. So first what you do, you check existing registered trademarks. You see, are you on the path to infringe someone's IP? Then you design your own trademark. Do it with style. Then you register your own trademark. But all this without proper packaging, marketing communication, and even small gadgets you will give away as a freebies won't fly. So do it properly and with style. And let me take you to the journey. We will explore innovative entrepreneurship pilot, and everything starts with the idea. And then you do some research, you encounter some dangerous guys, which might become your allies actually. You make some decision. You're always questioning yourself. There is a lot of suspicion and strategic options, and you can't take them all. And horrible doubts, but you are not even close to start your business. That's still pre-incubation phase. And then you do a lot of planning and you use aid from qualified and reliable helpers. And finally, you are unsure. But this is incubation phase and it's time for first troubles. You don't know enough about your business, but you will get it. Easier or harder? And then a lot of people are fooled with initial success, which could be serendipity, but could be also tests of their vision and mission. And then you would be tempted a lot. And I have important notice to make. Please remember, there is no such thing like safe shortcut to success. And the cave of cheated ones is an extremely crowded place, so don't get there. And then few of us would get to the summit where all dreams come true, but then you are facing eternal change. And then I already mentioned those guys, hustlers of all kinds. Then in the end, the ultimate goal is result of successful and retired entrepreneurs. But why did I tell that story and where IP actually fits in? Oh, you remember trees? On that row, you would find a lot of those trees in different vegetational phase. So bear in mind, they are just like key enabling technologies. They are there, but if you don't utilize them, no use. So do your assignment properly, create, protect, and commercialize your IP with passion and a high level of professionalism. We are already at chapter 7, do's and don'ts. So please do not understand this chapter as a replacement for professional advice, because IP is so complex and a couple slides of do's and don'ts cannot replace professional advice. Consider that as a set of rules that would prevent you from getting into deep trouble. So let's start with the do's. Rule number 1, respect your IP, because that could be the most valuable asset you've ever owned. And many people do not treat their own IP with appropriate respect. Number 2, be clear with the ownership, especially when it comes what is owned by who. Remember, creations, they are always done by physical persons, but ownership, exploitation of that IP could be owned by a corporation. Be clear who owns what. Rule number 3, pay attention to security. And I have to tell that I witnessed several very troubled cases where people were really secretive about their IP, their inventions with their trademark attorney or patent attorney. But then in the bar next door, they were talking about the biggest secret of their business to total strangers. Similar is happening with scientific conferences. And that's the play of ego. Scientists are simply keen to explain something which is not to be revealed at the scientific conference or trade fairs. Next is borrowed from Stephen Covey. Start with the end in your mind. Do the cost-benefit analysis first. It makes no sense to have a complex patent protection for a small project that would yield possibly 50,000 euro in its lifetime. So do the cost analysis first. Then it is about timing. Do it on time. And in most cases, this is at the very beginning of the project. But bear in mind that development of novel, cutting-edge, deep-tech product processes will take years, possibly decades. And filing it at the beginning could actually get you protection that would expire at the time when you are about to enter the market. So consider timing. Number 6, be aware. It's always territorial. There is no such thing like universal global protection of intellectual property. It is always territorial. You have to indicate states, territories, where you would like to have that protection. And it is about classes. It is not automatically to have all products and services protected. You have to indicate classes as well. Number 7, do it in layers, but pay attention to the order of filing. That's important for scientists. They would like to publish papers, and that's fine. That's totally legitimate. But if they only file the patent first, because scientific publication is the act of discovering your invention. And by doing that, you are actually undermining your patentability. Do it in layers, but pay attention to the order of filing. Number 8, be aware. Every protection instrument is very specific in terms of duration, prices, procedures. It is very easy to make mistake and confuse one instrument with the other and actually undermine your IP protection. Next is ask for qualified and reliable help. There is a plenty of qualified and reliable help around. So choose wisely. So 9 rules. Let's see about don'ts. First do was about paying attention to your IP. First don't is don't infringe, and it's related to respect of other people's IP. Then don't start with the beginning in your mind, and there is a danger. There are procedures that are really cheap at the very beginning and costly later. A lot of people would start with the beginning in their mind, and they would file protection, and then they would run out of money and eventually abandon that filing. Don't start with the beginning in your mind. Then don't do it prematurely or too late. Filing after your competitors already copied, and then you start your IP protection and then legal actions against them. Yeah, that's really filing in bad faith. Don't do that. Don't ruin your IP protection yourself by premature and inappropriate disclosure, like talking to strangers, talking to press, talking to your fellow colleagues in the conferences, or other inappropriate disclosures. Pay attention to confidentiality. Then don't fall for hustlers. We had a case in previous chapters about receiving interesting offers that makes no sense. So be cautious, don't fall for hustlers. And then, in most cases, you shouldn't do it yourself, especially in complex and extensive cases. So consult professional help. And there are so many more do's and don'ts. But those 15 rules are designed to prevent big and costly trouble. So pay attention to your IP. The first resource I will mention is ECIP help desks. And as you see, just like IP protection, help desks are regional. We have European IP help desk, China IP SME help desk, India, Latin America, Africa, and Southeast Asia. They offer a broad spectrum of services, and I would emphasize 3 of them. If you really have serious questions, you should contact your national ambassador or ambassador closest to your place of origin and doing business. Next is helpline. You simply write a question and you'll get the answer in 3 business days. And then publications. Publications aim to educate you in topics you are really interested in. There is a lot of publications, a lot of events, most likely more than you ever need. But it's good to know they are there. So the ECIP help desks. Next resource is European Union Intellectual Property Office. You go there regarding proceedings on trademarks and designs. They have excellent database, searchable database, TMView and DesignView, and they have a state-of-the-art educational program. So check EUIPO Learning Portal. Just recently, they have a new grant scheme, Ideas Powered for Business, which was a great success. So check Ideas Powered for Business website. Next resource is European Patent Office. They handle proceedings regarding patents. They have great database as PassNet, which offers free access to over 130 million patent documents. And they have great academy, so check EPO Academy. World Intellectual Property Office could handle proceedings regarding patents, designs, and trademarks. It is especially relevant if you go for extension outside of EU, and they have great educational programs, so check WIPO Academy and Diagnostics. Further, If you are in the business with new plant varieties, there are two institutions, International Union for Protection of New Varieties of Plants and Community Plant Variety Office, where you can register new plant varieties. Licensing Executive Society International is place to get assistance about an education regarding licensing. EN, the most powerful and largest business network on the planet, and you should go there if you want to find research partners, and about assistance in commercialization of IP at global scales. And this is it. Let me show you links to their web pages. And then, if you assume that would be the EN domain, let's click on it. Oops, it's busy. So pay attention. Do not assume too much when it comes to IP. So the domain is not like that. It's a little bit different. And then IP Help Desk, I mentioned at the very beginning, a good place to start your inquiry and your path toward commercialization of IP results. We are almost at the end. Chapter 9 is small IP quiz with just 4 questions. And the first one is about industrial property. This is your innovative product. The question is, what IP instruments are suitable to protect your innovative citrus squeezer? Please note that it is possible to deploy several instruments, and you have 90 seconds to define your answers. Okay, time's up. Possible answers are: it is reasonable to file a patent for a novel power mechanism. It is reasonable to file design for a distinguished appearance. If you have a new printed circuit board, topography of semiconductors is appropriate instrument. Trademark for brand name, trade secret for casing material, intriguing internet domain, and there are some more, but those 6 should do. Let's move to next question. It is about commercialization of said innovative citrus squeezer. So what are possible scenarios for the commercialization of your innovative citrus squeezers? Note, several scenarios are possible, and time is on. Okay, time's up. Let's see what are possible scenarios. First one, you can produce it in your own company or shared one. You can license your innovative citrus squeezer to existing manufacturer. You can sell your IP and move to another innovation. Or you can lease a professional version of juicy bar owners, meaning you are producing them, you are keeping them, and make money with the rentals. And there are certainly more business models that can work for you. Let's move to the third question. It is about copyrights. And this is your artwork. The question is, what IP instruments are suitable to protect your artwork? Note, it is possible to deploy several instruments. And time is on. Okay, time's up. Let's see how to protect your artwork. Definitely copyrights for photography, copyrights for text. It could be combined registered trademark containing picture and verbal expression. Of course, you can you can file just a figurative trademark or just verbal trademark, but those three instruments should do. The last question in our small quiz is about resources. Question number 4 is about resources. And we have 3 very special cases. You are designing a folding bike and you would like to check, are there any patents in a way? You are designing citrus squeezer. You are interested to see, are there any design that would affect your future development? And finally, are there any similar trademarks to your project? Time is on. Okay, time's up. It wasn't necessary to put the whole internet address, but you could do it. For patent search, SPINTeams is your database. For design searches, DesignView is your database. And finally, for trademark search, TMView is the place to go. And of course, those are only 3 possible solutions. There are many more public and commercial databases available. And that was it. Uh, I hope you successfully passed the examination. You have elevated esteem and you are ready to go and commercialize your IP. I am Professor Ivan Stefanic, and this is the end of Module 6, Intellectual Property and its Importance for Knowledge-Based Entrepreneurs. At the end, I'm really tempted to say that's all, folks, but I still recall cartoons with the same message. And I just wonder, would I infringe anyone's IP if I say so? The way to check is to go to TMView and see. There are 4 registrations. 1 of them expired and 3 of them still valid. But fortunately, they are valid in Brazil, United States of America, United Kingdom, which is not anymore part of European Union. So it is totally okay to say that's all, folks, if you do that in European Union. I hope you liked the webinar and it was inspiring and intriguing enough, so you decided to learn even more. If it is so, please let us know simply by liking the video on YouTube or sending us old-fashioned message. Thank you for your attention.